everybody. The idea of this morning is to give you a very brief, very short introduction to the law of contract, and specifically the two IOPSA standard contracts, namely the minor plumbing works contract and the contract for small plumbing works that was introduced last year. Because of the very short time, I cannot go into any detail about anything. My intention is to give you a very brief overview of the relevant principles of the law of contract, and thereafter just highlight important portions or principles which are contained in clauses in these two contracts. The South African law of contract is a hybrid. It comes from some extent from the Roman Dutch law, the writings of the 15th and 16th century, which we still adhere to, but it's also been heavily influenced by the English law due to the English colonialization of South Africa. So there are concepts of both of these legal systems that influence the way we think about the law of contract in South Africa. There are certain fundamental concepts of law of contract which we need to understand. The first is that in terms of our law, we have freedom of contract. You will of course know that this sounds a bit of like pie in the sky, because even though we have the freedom to agree to whatever we want to, there's always the power play between the parties which influences what one can agree to and what one cannot agree to. For instance, the fact that you want a certain price does not necessarily mean that the client will be willing to pay that price. The second aspect, and this is I think very important, is that we believe in the principle of sanctity of contract. Now that in principle just means that every contract is regarded as being valid and enforceable until such time as the contract is proven different from that. It is important in the light thereof that many people go into a contract with the idea, let's see what loopholes there are and let's see what way we can get out of the contract at some other stage. But this is not the fundamental principle in our law. The next fundamental concept is that we enter into contracts in good faith, which means contracts ought to be fair, and we ought to be open in dealing with each other. Now, especially the open dealing is quite an important factor, and that's why we have a lot of law and legal positions around misrepresentation, whether innocent, whether fraudulent, and what the law does in cases where people mislead each other when it comes to contracting. And the last principle is that of privity of contract. Those of you who sometimes are subcontractors to main contractors in bigger contracts will know that there is a fundamental difference between the relationship between yourself and the main contractor and the relationship between yourself and the client. That is what we call privity of contract. You have a direct contract with the main contractor and your only legal course lies towards the main contractor. The main contractor has his privity of contract again with the client, but you have no direct access to the client, in law at least, and your interests are not really protected towards the client, except in very limited circumstances, which the JBCC contract for even provides for in respect of nominated subcontractors. The next aspect of our law that is necessary that we look at what are the essential elements of a valid contract. Our law goes out from the point of view that if we do not incorporate the essential elements of a valid contract, the contract cannot be valid. The first of this is capacity. Basically means you must have the ability to enter into a contract. Now, I'm not very worried about whether you're a minor and you cannot contract at this stage. For your purposes, it's far more important to look at when you contract with a trust, with a company, with a closed corporation, that you are sure that the person who represents the company, the trust, or the closed corporation is actually authorized to enter into a contract with you. And that's why you will see at the bottom of many contracts we find the clause duly authorized, to make sure that the person can actually contract with you and that his principal will not turn around later and say, but he had no right to contract with you. Sometimes we also require a resolution from the directors or the members or the trustees to make sure that this person has the relevant authority and capacity. The next aspect that we have to look at, that our law is based on offer and acceptance. When you make a quote, or you give a quote, and that quote is valid for a certain period, that's an offer that you make to the client. And then the client accepts it, and only when the client accepts the offer does the contract come into existence. But for the purposes of the offer, it must be valid, and it must be valid in the sense that it must be definitive. It must set out all the conditions that are necessary. It must be complete. It must be clear. There may be no uncertainty about that, and it must be certain. It must be unconditional. Now, you will know that when one tenders on a bigger project, a tender is slightly different. The tender is not an offer. When you put in your tender to the client, that becomes the offer, and only when the tender is accepted does it become a binding contract. But sometimes we qualify our tenders, which means we put a condition to it. We cannot agree to this, we want this and this. We do not agree to your terms, we want different terms. And then when you do that, you actually make a different offer than the one that was requested. And if the client does not accept that, but he says, I'll accept it on the basis of the original tender conditions, then he makes you a new offer that you have to accept. And that comes from the fact that that an offer must be unconditional. The next aspect is that of certainty. Agreement must be certain and the terms must be certain. If it's vague, the court cannot uphold the contract. The next element is that of formalities. Now, in terms of our situation here, formalities are not really relevant. Our law does not prescribe formalities for normal contracts. It's only certain contracts, such as suretyships, that must be in writing, or anti-nuptial marriage contracts that must be in writing, certain leases, and the sale of land must always be in writing. The next element is that what you offer to do must be possible. If it's not possible, a valid contract cannot come into existence. And the last important element, it must be lawful. The element of lawfulness initially only had to do with whether it's against the law or not, but it has grown into the fact that when it comes against the public policy, then it's also not acceptable. There's one further aspect of the law of contract that I think we need to highlight, and that is what we call the parallel evidence rule. This comes from the English law. The basis of the parallel evidence law is that only that which is written in the written contract is part of the contract. Those parts that are unwritten and outside of the written contract are not regarded as part of the contract. This is a very important principle that you need to remember. All of these discussions between your client and yourself that might give it a different implication than the actual written contract is not enforceable, because that evidence about such extraneous negotiations will not be admissible as evidence in court due to the parallel evidence rule. And that is all to create certainty, of course. So the contract is regarded as the exclusive memorial of what the parties agreed. And I'm sure you will have seen that in many contracts, there's always a clause towards the end which says this is the entire agreement between the parties, and that no alteration or an addition thereto will be of any force and effect unless reduced to writing and signed by both parties. The certainty that's created about this is what our law of contract is built on. So I want to advise you here that if you're uncertain of whether everything that was verbally agreed on and whatever representations of the client that you are relying, that should be added as extra clauses to the contract to make sure that it forms part of the written memorial between the parties. I now want to move on to the two contracts that IOPSA offers, the two standard contracts. The first of that is the small plumbing works. The question that I'm always asked is what is the price difference or the cost difference between a minor works and a small plumbing works contract? And I never know what to answer to that. The reason for that is that it depends on what the material costs are, depends on what is being put in, what equipment is being used. The easiest way to distinguish between these contracts is to say the small works contract is meant for small works, mostly at private homes or at where there will still be substantial occupation, and that the duration of the contract is not going to be very long. It mostly refers to contracts where you do not have total control over the site. Whilst the minor plumbing works contract is for larger contracts where you are the main contractor, and where, although there's no principal agent involved, where there will be requirements for securities and not only um, uh, and retention, and not a case where you will, for instance, just ask for a deposit from the client. I'm not going to go through the contract clause by clause. I do want to highlight certain things about the small works contract. Different from the minor works, this allows you to ask a 50% deposit up front from the client, and the remaining balance to be paid when the work is completed. The second important aspect of this contract is to avoid squabbles about payment afterwards. And therefore, we say that where there are defects in the work which do not substantially influence the use of the works, the client cannot withhold the monies. Now, you will see when we get to the minor works contract later on, this is the difference between practical completion and final completion. Practical completion meaning when the works are substantially fit for the purpose it was used and can be used. So if there's a huge water leak that spews into the road, obviously that prevents the client from using the works. And that will then not be practically completed, and it will have to be repaired before you reach practical completion. But where there's only a slight trickle from one of the joints, obviously it does not influence the enjoyment of the work that's been done. And that is a patent defect that can be repaired afterwards, and the client will not be entitled to withhold money on the basis of that. Both contracts provide for the variation of the works, meaning that extra work can be given, or the work that has been contracted may be changed slightly, but there's always a limit to what extent the works can be varied. It cannot be varied to the extent that it becomes totally a new contract. An important factor in the small works contract is that any unfixed materials that are on site remains the property of the contractor. I think this is very important because there will probably not be a lien. You will not be able to lock off the building and say, I won't hand over the building to you until such time as you paid me in full. It's a way of keeping security, and it's also a way of retaining ownership of extra materials that remained on site. It's unfortunate, but we have to write this into contracts because sometimes it doesn't happen, but there's an obligation on the contractor to leave the site clean and tidy. And there will also be a duty on the contractor to at least try to take reasonable steps to protect the furniture, the floor coverings, and other valuables of the contractor, although the contract does not place a duty on the contractor to make sure that nothing is stolen, because that is not necessarily out of your control. There's also a duty, or in your control, there's also a duty on the client to make sure that he protects valuables so that it is not stolen. A further important factor in the minor works is that whenever you supply materials, for instance, a geyser, you will cede that warranty on the geyser to the client at completion of the works. That takes you out of the equation. It means that in future, he will have to go back to Quickheart himself to call up that guarantee, so that if there's work to be done, that work does not come down onto your account. And then, of course, where the client supplies the materials, the client carries the risk for any defects that there might be in such materials. Because the nature of minor works can differ substantially, we provide in clause 9 a choice for the contractor and his client to choose how long the guarantee will be on the works, and it can vary anything from 3 to 12 months. And those are the basic principles of the small plumbing works contract, which is which we included in that, which makes it slightly different from the minor works. When we go to the minor works contract, the first thing is you are the main contractor in a contract like this, which would mean that there will be no other main contractor. You will directly contract with the client. And for this specific contract, there should not be a principal agent who gives instructions. The agreement or the negotiations will be directly between the plumber and the client. I'll try to break up the basic principles into a few categories that we just talk in terms of categories here. The first is risk in insurance. In every contract, we go out from the point of view that we have to divide the risk for the works between the client and the contractor on the other side. Now, in terms of the minor plumbing works contract, the risk that's on the contractor is that you have a duty to diligently commence with the work, to execute the work, and to complete the work, and that all work should be complying with the applicable SANS standards. I think one of the greater risks that you have on any contract is that you must complete in time so that you avoid penalties if there are penalties in the contract. You will carry the risk of protection of the works and of the materials until practical completion is achieved. You have the risk to make sure that the materials are on site at the right time, and you will have to carry the risk of any cost increases that might happen during the course of the work. The client, on the other hand, has the risk that he must give you unhindered and uninterrupted access to the site. Now, this is very important, as you know, that if there's a time period in which the contract has to be completed, and more particularly if there are penalties involved, if you do not get access to the site at the right time and unhindered and uninterrupted access during the whole construction period, you cannot take the responsibility to complete on time. Where the client has to provide materials, he carries the risk of supplying it timelessly and any defects in materials. The client must supply all water and electricity as well as toilet facilities, and when there are no toilet facilities available, the client must carry the cost of temporary facilities. If there are any plans to be approved, that is for the client to do. If there are any requirements of the local authority, also that falls on the client. And in cases where there must be soil testing or blasting, that cost and responsibility also lies on the client. The next aspect that I want to look at is insurance. The contractor has two basic insurance responsibilities. The first is, of course, to belong to and to pay over your workman's compensation so that your employees are covered by the COIDA Act. And then, of course, you have to have third-party insurance should anybody else be injured on site. And it will probably be included in your contractor's all risk. In some cases, you do carry the responsibility for loss or damage on the property, things like theft or damage to the structure, but it depends on whether there's occupation on site. If there's occupation on site, obviously you cannot take responsibility for the cost of theft, and the client should make responsibility or should make provision for that by means of his homeowner's insurance. Insurances that the client should cover is force majeure. Now, I'm sure you're all very well aware of force majeure and vis major at the moment after the lockdown and the responsibilities that were carried by that. Now, any costs that are lost because of that lies on the client. For instance, the extension of time and the losses that go with that. The client also carries responsibility for latent defects in any materials that were specified by trade name. Any losses that is caused by the acts or omissions of his employees, servants, or agents. If there's any interference with servitudes or lateral support. Any physical loss or damage where it's alterations or additions, meaning that there is occupation on site. And then any losses due to the occupation by the client or its own tenants. The insurance that is recommended here is that it must be 10% of the contract sum where the contractor carries responsibility. In terms of retention, we've made, or security, we've made provision for two different options. The form of security, which is a bank guarantee in the form of a performance guarantee, or retention to be kept by the client. But it also provides for the contractor to require a payment guarantee or a cash deposit from the client. Just want to quickly refer to the builder's lien. Where you have sole access to the site, obviously you can lock the site and you can prevent anybody to have access to it. In such a case, you can exercise your builder's lien for as long as you keep presence on site and keep the site under your control. But where we have occupation by the client, is as in the case of renovations and additions, that is definitely not possible to keep that presence on site, and that is where one has to relinquish the lien but may ask for a payment guarantee. I've quickly referred to practical and final completion when we were talking about the small works contract. I just want to reiterate that practical completion in general means that stage of completion where the work is fit for the purposes it was installed or built, and that the works can be used for the purposes intended. And final completion is when all the snags are completed. Obviously, the contract provides for extension of time, but the extension of time provisions are not as formal and as specific as those that you would, for instance, find in bigger contracts, such as the JBCC contract. We've tried to write it in a manner that it's as wide as possible to allow you to claim for extension of time under most circumstances. And the principle we're talking about here, that you are entitled to fair and reasonable extension of time where there's any unforeseen delays. Unforeseen means that you and the client ought not or would not have been able to foresee that, but also that you could not have prevented that by taking reasonable steps. There is a notice requirement of 10 days notice, and you do get automatic extension of time for shutdowns and public holidays. Different from the JBCC, there will be no compensation for P's and G's, but where there are, of course, variations and there extra work to be done, in cases like that, you will be entitled to extra to extend or adjustment of the contract price. Lastly, I just want to touch on variations. Once again, the contract can provide or does provide for variations. A variation is any change in the scope of the contract or additions that is granted or requested, but cannot vary the entire scope of the contract, that you cannot recognize the contract anymore, because then it becomes totally a new contract. It is preferable that you agree the value of the variation with the client upfront to avoid any arguments and disputes. But even if you do not, we have written in a formula in the contract to allow you to calculate those costs, and that will be the cost of materials plus 10%, the cost of labor plus 40%, and the cost of plant and transport plus 15%. It also makes provision for where you have to employ a subcontractor, that you're entitled to a 15% markup or attendance fee on the contractor's price. And that is the entire presentation. Thank you very much for attending. I hope you learned something from this.